All right, so we are recording right now. So we're gonna still wait a few more minutes just to give some more people, if there's gonna be anybody else joining in, and we're gonna go over acceptance for value. Let me see if I can share that right now. And I'm gonna give a. Meanwhile, we're waiting, right? I want to share something with you guys. But on the chat, let's just test something out. Can you guys all hear me? Can you just put a little
Yeah, I
comment in
can
the
hear you.
chat? Everything's good. All set.
Yeah.
All right, perfect. When I just started this whole process, one of the things that I started learning about was about common law, and that how we need to invoke common law. And I was listening a lot to, well, not a lot. I was listening to talks and discussions from this guy called David Straight. He was one of them, and a few others. And they were saying basically, when you go to court, you got to bring in your uh, 12 uh, living men and women, so you can have a trial by jury and do a big deal out of all this. And I've come a long way to where I realized that ever since the system changed from gold and silver to negotiable instruments completely, um, it might appear that it's a bad thing. But honestly, the more I learn about this whole system, and the whole negotiable instruments and securities, the more I learn about this system, the more I realize that actually this is very beneficial, because gold in a way represents, like, for example, if I was to go for a few months to go dig for gold, right, in the time like 1900s, in the early 1900s, and I take a few months off to go dig for gold and bring it back to the nation which I'm from, or the country I'm from, that gold represents, in a way, the amount of energy and labor which I put in. So it represents past labor, past energy. And where is that energy coming from? From the great divine. So it represents divine energy that is being, or that has been already invested in. So gold in a way represents past energy, and it seems that and again, this is only my opinion, and we transition to now using these promissory notes, which obviously represent future energy. So both of these instruments, or both of these different, I would say, technologies, one represents past energy, the other one represents future energy. And we are people, or we are beings that, if we were to reset from scratch again, obviously we would figure things out and progress. We're progressive. We're always progressing. We're always adapting. They call it evolving. So I would say that the previous system, the old system, compared to this new system right here, that was like an older technology, and we just adapted. It's like when we have a phone, and the more we use it, we see that we have to upgrade and install new software because of the adaptation that it is required now. So, oh, and I just want to say, now that we're recording, is that nothing that is being said here is going to be, I don't want nothing to be taken as legal advice whatsoever. We're simply going to be going over publications, and um, just opinions that are being shared. I'm not going to be sharing any real documents of mine. I don't. That's not what we're going to be doing right here. But we will have some talks and discussions here and there. But mainly, I'll be just reading these documents here, or these publications, and we'll stop every once in a while to maybe discuss a few things. But then, basically, just reading. This is very important to understand what we're doing. So it's 6:09 in here, Belize. We're gonna wait a few more minutes, maybe 2 more minutes at that. Then I'm gonna start reading. Um, yeah. So when we look at the court system right now, how it operates, it's just generating all these bonds and these securities, right? And we uh, we can actually use the system to our benefit if we understand it. That's how I'm interpreting all this. The more I learn, and that's why I think as a group of us, because there's a lot of us learning about this, I think it's good that we come together in this fashion and this manner to read these documents and publications, and so we can better understand it. That way, we can come as a stronger force, or we can be a stronger force and not be so incompetent, like they say. So it is 6:10. All right, I think it's good. I'm gonna do a screen share now. Present screen share. Acceptance for value. Okay, here we go. Hmm. Here we go. What does acceptance for value mean? I ran into this publication when I was learning from. There's this guy called Adam. He talks a lot about reclaiming your securities. You can Google Adam. I think that's his name. In YouTube, he has a lot of good videos. He's always talking about reclaiming your securities. He always says man does not exist in commerce, and he says a lot of good stuff. But he recommended this document right here, and I got it last year, and I read it. I've read this document, this publication, probably about 3 times. This will be the fourth time, and every time I read it, I gain more knowledge. Let me expand it a little bit. So it says here, hold on, let me see if there's anybody before I start. Let me see if there's anybody else that needs to come in. Sabea got kicked out, but she seems to be having a hard time coming in. Let's see. Okay. All right. I'm going to start reading, guys. All right. It says here millions of people use the phrase accepted for value every day without knowing what it means and why it is so powerful. You have the right to make personal choices that affect your commercial affairs. You can be in control or can be controlled. Acceptance for value is one means of being in control. Now, this publication right here, he also gives other recommendations. Let me see. Here we go. There's some recommendations if you guys want to do more studying on your own. We're probably going to go over some of these too in our studies. America, National or Federal, In Search of Liberty. Here's some booklets: Superior Law, Higher Law, My Law, Introduction to Corporate Political Science. I'd sure like to read that one. Introduction of Law Merchant is what we read last week. Society of Slaves and Freedmen. We learned from the introduction of Law Merchant that freedman basically just means slave. It's a slave that doesn't appear to be a slave. And let's see here. Sovereignty, the legal system for sovereign rulers, negative side of positive law. We also learned about positive law, reading Law Merchant, shed a lot of light as to how it is synonymous with substantive law. Man-made laws, right? This is where slavery can become legal in a way. So this must be a good read. Liberty, when there is no money. Probably going to go over that one as well. The natural order of things, resident minister. All right. Agree with thine adversary quickly while thou art in the way with him, lest at any time the adversary deliver thee to the judge, and the judge deliver thee to the officer, and thou be cast into prison. Verily I say unto thee, thou shalt by no means come out thence till thou hast paid the utmost farthing. Now, this right here reminds me of legalese. When I first read this, I was like, what the heck is all this? But basically, if you look into it, it basically means is that we just have to agree before when we go to court, or if we ever have to go to court, best thing is to try to settle outside of court before going to court. Trying to settle is basically agreeing. And there's a word called stipulation. That's a beautiful word to use in your documents, and it's a type of agreement. So this is it's a nice verse right here. Okay, let me see if there's anybody else who is waiting to come in. Set this in. All right, that's cool. All right, let's get started. I don't see anybody else. What does accepted for value mean? Accepted for value is the foundation of remedies available for commercial demands. Hello? Yeah, can you
This is
guys
Alexa's dad.
mute while
I'm in the middle of a class. What's going on?
hold on, let me mute that and mute this. Okay. There you go. Perfect. Okay, let me start again. Accepted for value. It is the foundation of remedies available for commercial demands made by the United States. Again, the United States Corporation. So many people have attempted to use it to close accounts in the US, the United States. Even so, no one has had a good explanation of what A for V means. Here is an attempt to clarify. Introduction. The Uniform Commercial Code in Article 3 that deals with negotiable instruments is one source of explanation. Article 8 deals with investment securities, and Article 9 deals with secured transactions. Okay, so you see there's a distinction right here. They're making a distinction, clearly saying anything that has to do with negotiable instruments, that's governed under Article 3. When you're dealing with securities, that's Article 8. When you're dealing with secured transaction, that's Article 9. In addition to opinions written by judges to shed light on our remedies, all three of these articles hold a key to understanding commercial setoff. The UCC had an overhaul in 2000, but the major principles remain the same. The changes appear to be to the section that deal with secure transactions, which is Article 9, and some with investment securities, which is Article 8. Okay. But negotiable instruments are what led to those securities. The phrase accepted for value has little coverage in the code books or in the court opinions. A better understanding of the commercial terms acceptance and value and how they relate to instruments in general would be a good place to start. Acceptance. One, an agreement either by express act or by implications from conduct to the terms of an offer so that a binding contract is formed. If an acceptance modifies the terms or adds new ones, it generally operates as a counter offer. Accept means to receive with approval or satisfaction. Also, to receive with intent to retain. Acceptance. The taking and receiving of anything in good part and as it were, a tacit agreement to a preceding act, which might have been defeated or avoided if such acceptance had not been made. Blacklaw's Dictionary. Number 4. A naked acceptance waives remedies that are available by waiving defects in the instrument. Okay, so remember, waves means to forfeit. And this is a word, let me show you. I'm going to show you this. Let's do this. What is the legal definition of waive? I'm going to share this screen with you guys. Give me 1 minute. Because I run into this word a lot, and especially in the studying securities, and I read the agreement in that I have a few accounts in, and they talk about. I could share this tab instead. Here we go. Let's see what Investopedia has to say. Waiver is a legally binding provision where either party either party voluntarily forfeit a claim. So they let's see, waiving defects in the instrument. Now, defects, right? This one right here, when we look it up, it actually means, like, let's say there is already a lien on the title, right? And you're trying to do something while using the title, but you're trying to gain control of it, but there's already a lien on it, but there's a defect in it. So that's what it means. That's what I've come to learn. The naked acceptance waives remedies that are available by waiving defects in the instrument and agreement that is being offered and accepted. Receiving an instrument is an acceptance and a taking. Retention is the basis for a binding contract if there is a preceding act, like a pledge to the United States. Altering the terms of the instrument and returning it operates as a counteroffer. According to the UCC 1-201 general definitions, value, except as otherwise provided with respect to negotiable instruments and bank collections, section 3-303, 4-210, and 4-211, a person gives value for rights if he acquires them. So he gives values for rights. In return for a binding commitment to extend credit, or for the extension of immediately available credit, whether or not drawn upon, and whether or not a chargeback is provided for in the event of difficulties in collection, or as security for or in total or partial satisfaction of a pre-existing claim, or by accepting delivery pursuant to a pre-existing contract for purchase, or generally in return for any consideration sufficient to support a simple contract. Okay, so now that says a lot, right? It's a bunch of legalese right there. Let me read one more time, right? I'll just read it one more time. It says, value, except as otherwise provided with respect to a negotiable instrument or to negotiable instruments and bank collections, a person gives value for rights if he acquires them in return for a binding commitment to extend credit. So let's say you fill out an application, and that's on your own free will, right? Application, that could imply applying credit, right? For what intention? Well, to extend credit, right? For the extension of immediately available credit. So you see how it says available credit? Because we always have credit. Whether or not drawn upon or whether or not a chargeback is provided for in the event of difficulties in collection, or as security for or in total or partial satisfaction of a pre-existing claim by accepting delivery pursuant to a pre-existing contract for purchase, or generally in return for any consideration sufficient to support a simple contract. And remember, a negotiable instrument on its own is a simple contract, because as soon as you accept it, you know, there's a lot of implications when somebody hands you a piece of property, especially like a negotiable instrument. So it is a contract. So it says here UCC 1-201 generally says that a person gives value. He gives value to get rights. If one person is giving value, another person is asking to give rights in exchange. Both giving value and giving rights meet the element of consideration. The question has to be, what constitutes value? In today's commercial system, where ownership is not the prime focus, interest rights in things takes the place of ownership as the goal. So he says, let me read that again. In today's commercial system where ownership is not the prime focus, but it says here interest, which is rights, in things take the place of ownership as the goal. A security interest constitutes a right to seize control of a pledged thing if the one giving the security interest fails to perform as agreed. The one giving a security interest retains possession of the thing that secures the right of another party to seize possession of the thing that backs the security interest that was given. The one receiving a security interest becomes a secured party, especially if the instrument establishing the security interest is registered. He has rights, which are remedies and defenses that he can use to enforce an agreement if the other party fails to perform as agreed. As UCC 201 general definitions. Let me say something in regards to this, right? Earlier we were talking about you giving value for certain rights. As we can see here, we got to take this into consideration. When you say rights, they're talking about interest as well. That's what it's implying, right? So you give value for rights. So value for interest. Now just think about that one. Okay, just keep that in mind. And then also, the one receiving the security interest becomes the secured party. So we're always saying, yeah, we want to be secured party, but sometimes you got to give up that interest if you want to do a set off. And we'll learn more about that as we go along. Let's continue reading. Rights includes remedies. A remedy is a commercial right for those who acquire that right through an instrument. In corporate United States, there must be a written record of everything. Nothing is supposed to be assumed or presumed, but that does not mean assumptions and presumptions are not used every day to acquire rights and enforce them. If the right that is being enforced is a security interest in a tangible or intangible thing, it usually comes from an instrument that is actually supported by the thing. This is usually, but not always, a pledge or a promise to relinquish possession of a thing if there is a breach of an agreement. Because enforcement of a contract based on an implied promise is weak, an instrument demanding performance on it is an offer to initiate a new contract based on an old antecedent and may be implied or unenforceable contract. If an instrument is based on an intentional written promise to perform and an intentional pledge to relinquish property. It does not have to be issued for value. That's interesting. It doesn't have to be issued for value, but for interest. Let's say go. It is just issued, and the original contract with the offerer's right to the pledged property is the consideration that supports the demand. A copy of the written promise and pledge can be attached to the instrument, or the instrument can just refer to the contract by its title, number, or data, etc. The issuer of the instrument demanding performance supported by a written promise has defenses if the debtor files a complaint against the issuer for making the demand. This is highlighted because it's very fundamental. Let me read it again. The issuer of the instrument demands performance supported by a written promise has defenses if the debtor files a complaint against the issuer for making a demand. Now, this remember that if we receive a bill, right, from the utility company, or we receive a birth certificate from the state, they are the ones issuing that. So it says here the issuer of an instrument demanding performance. So when they issue an instrument, there is performance attached to it, supported by a written promise, has defenses if the debtor files a complaint against the issuer for making the demand. So this is one of something that these utility companies and corporations, they use this because they have rights as well as issuers. So the issuer can produce the antecedent contract that contains the intentional promise to perform and the intentional pledge to use tangible or intangible property to secure that performance. If the debtor is aware that he had previously signed a promise and pledged his right to a thing to guarantee his performance, he would not have to see the contract. The demand instrument is issued to get performance already promised, or in the alternative, to get the thing already pledged. In some cases, there are no pledge to support the instrument, so it must be issued and transferred for value with implied consideration. There is no debtor. The issuer does not have a written instrument to back his demand instrument. If he decides to issue the demand instrument, in spite of his lack of authority, he is risking liability on the instrument. If the transferee, the one who the issuer directs the demand to, calls the issuer's bluff, the issuer could be made to pay the transferee. The issuer, which is the transferor, has no defenses. He has no antecedent contract to attach as consideration for the demand he is sending to the transferee. If the issuer has no written pledge but still decides to issue a demand, the demand instrument must be issued for value because there is no evidence of pledge to attach to it. There is no written antecedent contract obligation that requires the transferee to perform, but he still has to do something with the demand. Let me see if there's anybody that needs to be put in here. Okay, let me continue reading. The transferee is the one who receives the instrument. See, the transferee is the one who receives the instrument by mail, by process server, or by warrant. The transferee is a target. The issuer is shooting the instrument at the target, hoping that the target will just take the shot and agree to become liable on the new offer. The issuer is bluffing. If the transferee recognizes the demand instrument as a bluff, he can call the issuer on the bluff and require the issuer to pay. The transferee actually gains a security interest in the instrument if he recognizes it. If the instrument is issued and transferred for value with implied consideration, the transferee acquires a security interest or other lien on the instrument if it was not obtained by judicial proceedings. See UCC 3-303. This is what they do a lot, though. They just, they just shoot instruments at us by sending us bills all the time. And what we're doing right here, learning how to behave as creditors or how to act as creditors, we are learning how to call their bluff. That's what we're doing. And when we call their bluff, we can actually do something about it. See, it says here the transferee actually gains a security interest in the instrument if he recognizes it. If he recognizes it. And anyway, let me read on. If you properly endorse an instrument issued and transferred for value, you acquire a right to enforce the instrument against the issuer. You become the creditor by returning it to the issuer, who becomes a debtor. By accepting the instrument, an offer for value, you are altering the terms of the offer and it becomes a counter offer. So it was like what we were talking about earlier, or what was mentioned earlier, that um, when we get offered an instrument, we can accept it and it creates a whole new contract. So the way we respond to that, the way we perform after that, uh, by accepting the instrument for value, we are altering the terms of the offer and it becomes a counter offer. Right? So we can now send it back. So let's say we get a bill, right? And we convert it into a bills of exchange. And when we send it back with written instructions and demands for rights, what we're doing is we're sending back an instrument of value, because now that is going back to them as an asset. So now they become the holders of an asset, meaning they become the debtors. Right? Let's see here. If an acceptance modifies the terms or adds new ones, it generally operates as a counter offer. So once we send it back to them, we're giving a counter offer. So that means when we received it, it was an offer. So when we send it back in a particular way, it could be a counter offer. Okay. The right to be the creditor is what you get when you A for V an instrument that is issued and transferred for value, like a tax bill, a penal action indictment, or speeding ticket. These issues are all based on violations of statutes. Dishonor has value in the public. The violation of statutes has value in the public. The violation of the statute is the presumed basis or consideration for issuing the instrument. But if you have not promised to perform under those statutes, you are not obligated, and the issuer has no way of supporting his demand instrument. Mm. It is issued without consideration. It is issued based on a presumption that every U.S. citizen has pledged allegiance to the United States and to its private laws, which are the statutes. It's a bluff. The river card has already been turned. You have the winning hand. You can call the issuer's bluff. You can check, you can raise, you can fold. It's your choice. You have the button. The commercial system of the United States is based on the law merchant. That law is not neutral. It is not set up to be fair. It is set up to facilitate collection for creditors, especially foreign creditors. It deals with debtors and creditors even when there is no debtor-creditor relationship. The only thing that has to be determined in most situations is who is the debtor and who is the creditor. Once that is determined, additional facts are usually irrelevant and immaterial. In the United States, every man is deemed to be a U.S. citizen, and every U.S. citizen is deemed to be a debtor. A for V is one way of establishing that you are a creditor and not a debtor. If you're going to use the law merchant to settle disputes in the United States, a firm understanding of law merchant is necessary. If you have commercial rights, the trier of facts in the commercial dispute will proceed cautiously to avoid denying you commercial due process. Commercial due process is not much more than time and opportunity to complete an administrative remedy and produce a counterclaim. Let me read that again. Commercial due process is not much more than time, an opportunity to complete an administrative remedy and produce a counterclaim. If you don't know what your administrative remedies are, you probably don't have any commercial rights to exercise. As one who represents a person in the United States, i.e., a U.S. citizen, you have due process rights through the sovereign statutes. As a man in the several states, you have due process rights through your Creator's natural order of things. Properly applied, commercial remedies incorporate the natural order of things. You can choose to use a sovereign statute or commercial remedies, but they should not be used simultaneously. They're like oil and water, they do not mix. If you are going to use commercial remedies, injection of statutory rights will kill your commercial due process remedies. The terms of the offer and acceptance make the law that will be enforced. So basically, just talking about public and private. Sovereign statutes, it's private commercial remedies, that's public, they don't mix like oil and water. Even though you might choose to use commercial remedies, you still need to use a person to represent in the public to access the commercial remedies. They have been statutized in state law. You can use them, but you cannot cite the source. The statutes use the natural order of things as the basis for their code sections, and then if incorporate the incorporate the private policy code sections into the same set of public published statutes. If you use the site UCC blah 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 or USC blah blah blah, you have reverted back to being a US citizen, taking a benefit from the statutes. If you demonstrate a principle in the code section without citing it, you maintain your separation. The person you represent in the public acquires the commercial rights, but you interject your rights through a natural order of things and maintain your unalienable rights. You get to use the person instead of it using you. A person can acquire commercial rights through several means. According to the definition of value above, he can acquire them A, in return for credit, or as a security, or through a delivery pursuant to a contract, or in return for any consideration. Each of the subsections A through D deals with a different scenario. The last one, D, is a general catch all that covers anything that might not have been addressed by the first three. This definition is one of the most confusing in the commercial code and is one of the most important to understand. And they're talking about this in return for any consideration. A right is defined as a remedy. Debtors' remedies often include defenses against foreclosure on the express or implied terms of an express or implied agreement for which security was given. Defenses are often given to debtors as consideration by creditors, and defenses are often given to creditors as consideration by debtors. Money and things are not needed under this commercial system, where interest in things like real estate, bank accounts, and bodies serve as consideration. So see, the interest serves as consideration. For example, a creditor may sign an agreement giving possession to a product, giving possession of a product to a debtor before the debtor has paid for the product. In that case, the debtor has defenses if his creditor later accuses him of taking the product without paying for it. In the same transaction, the debtor may give defenses through the agreement to his creditor if the debtor later claims the product he received was not what he ordered. The written agreement identifies what the debtor actually ordered. The agreement will specify the terms of the agreement and the defenses each party gives to the other. Those defenses are rights that will result in a remedy if one of the parties is later wrongly accused of a breach. The people have commercial remedies if they are accused of a breach of some unknown contract. The accuser might claim a security interest in an antecedent claim against property supposedly pledged as a security in exchange for value that was supposedly given by an accuser. That kind of claim would have to be issued for value because the accuser would have no written agreement as the basis for his claim. His claim would be a new offer. He would be trying to get you to join in a new contract by implying that the antecedent contract existed. Since it does not exist, the issuer of the new offer has to be bluffing. Hmm. That happens a lot and frequently. That's how they say that's how they get us. All right, let's see. We're already 40 minutes in. Hope you guys are okay. We are on page 11. Let's continue reading. A for V is based on contract law. So acceptance for value is based on contract law. Listen to that. If you think there is a presumption of a pre-existing contract through which you are presumed to be a debtor that has supposedly pledged property and your liberty as security for some presumed value given by the United States, it might be very important for you to negotiate some better terms in a counteroffer. If the issuer of the instrument for value does not counter your counteroffer, you are in a much better position. If you have a record of a valid contract that contains terms in your favor and can be enforced in commerce, you have remedies. If you don't, the United States may be entitled to enforce a different agreement. Even if you have an agreement advantageous to you, your actions may imply a waiver and your consent to abide by a less advantageous agreement. This is where the process, the private administration process comes into place, because when we're sending out notices, remember, the doctrine of notice is at the heart of equity. So by us giving notice by itself, it's already consideration, right? Now, when we are sending notices, what we're doing is we're doing a counter offer at the same time, or we're doing an offer. Either we're offering something or we're counter offering. And in that counter offer, remember, again, if we're doing an A for V, it has to follow contract law, um, or, the rules of contract law. And it has to have certain characteristics in there. And this is, we're probably going to get into that in our next study session about contract, how to put these contracts together so that it is in our favor, right? And it doesn't, and there's no implication that we're waiving any of our rights. Pre-existing or antecedent claims can be created by agreement between the actual parties. But when the United States is a party, all agreements incorporate an attachment to a national debt. All agreements, whenever the United States is a party of it, a national debt is attached to it. An antecedent claim other creditors have against the United States. Oh, okay, all right. Let me read that again. Pre-existing or antecedent claim can be created by agreement between the actual parties, but when the United States is a party, all agreements incorporate an attachment to the national debt. An antecedent claim other creditors have against the United States. It is like a program running in the background on your computer. The presumption that all US citizens have pledged allegiance to the United States and its statutes is enough to establish an antecedent claim in favor of the United States. US citizens cannot question the national debt. They are called upon to be sureties for the debt, and they usually lose when a court proceeding is initiated against them for violation of statutes. This is done on the principle that the United States is more likely to pay its debt if it can collect from its debtors. United States courts take jurisdictions of cases where the to the United States is being charged with violations of United States statutes. Even though a U.S. citizen does not have a direct obligation to the creditors of the United States through the principle of novation, U.S. citizens generally agree to be liable without knowing they have done so. A person can transfer his rights and obligations to another party through an agreement. A owes B. A or B can ask C to take on A's obligation. If C agrees and A and B are given notice that C has agreed to owe B what A owes B, the novation is complete, and A is relieved of the obligation of paying B. The U.S. citizen is C in this example. A is the United States, and B is the creditors of the United States. Let me read that again because this seems to be very important. Let me read it again. This is important. Let's see. The United States court takes jurisdiction of cases where a debtor to the United States is being charged with violations of United States statutes, even though a U.S. citizen does not have a direct obligation to the creditors of the United States. Through the principle of novation, the United States citizen generally agree to be liable without knowing they have done so. A person can transfer his rights and obligations to another party through agreement. A owes B. A or B can ask C to take on A's obligation. If C agrees and A and B are given notice that C has agreed to owe B what A owes B, the novation is complete and A is relieved of the obligation of paying B. The United States citizen is C in this example. A is the United States and B is its creditors of the United States. The Commercial Code is first and foremost concerned about repayment of the national debt as a pre-existing contract with an antecedent claim. The secondary function of the Commercial Code is to provide an orderly method of dealing between other debtors and creditors. United States codes, statutes, violations, or claims used by creditors of the United States to collect internal revenue from U.S. citizens to pay the national debt. There can be claims stacked on claims. It is not uncommon for a totally discharged debt to be renewed by a creditor without the knowledge of the debtor. United States statutes are designed to transfer private rights from the private to the public for public use to pay the national debt. You hear that? The United States statutes are designed to transfer private rights from the private to the public for public use to pay the national debt. So they're saying that the statutes are generally there to pay the national debt. Every evidence of debt in the United States has value. Persons in the United States carry on commercial transactions by giving and receiving value. Value has nothing to do with things until there is a breach of an agreement. when an interest in the thing is transferred from the debtor to the creditor. On the private side, a thing is an object that casts a shadow. On the public side, only the shadow can be seen. On the public side, the shadow is given value. Interest in the thing is the value. It is not the thing. Hmm. Value UCC 1-201, general definitions, value, except as otherwise provided with respect to a negotiable instrument and bank collection. Let's read it again. A person gives value for rights if he acquires them. In return for a binding commitment to extend credit or for the extension of immediately available credit, whether or not drawn upon, and whether or not a chargeback is provided for in the event of difficulties in collection, or as security for or in total or partial satisfaction of a pre existing claim, or by accepting delivery pursuant to the pre existing contract for purchase, or generally in return for any consideration sufficient to support a simple claim. This word here, purchase, I want to show you guys what this means. This is an interesting thing right here. Purchase. Let me bring up the definition. I found the definition of purchase in this in in uh in the laws here in Belize, and it was really interesting. And I want to see just the legal definition. Let me share this with you guys right here. Well, this is according to the UCC. Let's look at the word purchase. Here you go. Purchase means taking by sale, lease, discount, negotiation, mortgage, pledge, lien, security, issue or reissue gift, or any other voluntary transaction creating an interest in property. Okay, that's interesting. But let me show you what it means in the other document. Here we go. Security Industry Act. We have a publication here in Belize that they just enacted it in 2021, and it's called the Securities Industries Act. I want to show you guys this, and it's just like a codified UCC. Let's see, share this tab instead. Okay, this is it right here, and this I found the definition of purchase here far more revealing. I'll show you right here. Let's see. Sure, marketplace. Here we go. Purchase. Here you go. Purchase. It says here, purchase includes any purchase, all right, or acquisition of a security for valuable consideration. It's just the acquisition of a security for valuable consideration. Now there is a tax. There's a tax form called a 1099-A, which says acquisition of secured property. Isn't it interesting that that's the definition of purchase, which is an acquisition of a security for valuable consideration? What we're doing is we're transferring over a piece of property. Whenever we're doing a purchase, we're giving them an asset. They're receiving an asset. So if we report it, we're reporting an acquisition of secured property. Let me go back to acceptance for value. All right, back. Computer is a little slow. Hmm. Okay, here we go. Let me read this right here now. Subsection A of 1 20144 can be read from the perspective of either a lender or a borrower as the one extending credit. Both parties receive rights from the agreement. Only the people have the energy needed to create money in the United States and in today's system. Credit and security interest circulates as money. So this is very, very good news right here for us. Extremely good news. Creation of money remains in the same place it always was, with the people. Before 1933, people dug up the gold and silver out of the earth, took it to an assayer to have it coined by authorized agents of the United States and spent or loaned their coins into circulation. Hmm. Since 1933, the people sign notes on their own credit, have that credit converted into currency by authorized agents of the United States, and spend it into circulation. After signing notes on their own credit, the people usually get into another unintended contract and agree to give a security interest in something as value on a contract they don't need and don't even want to enter. Article 1, Section 8, Clause 2 authorizes the Congress to borrow money on the credit of the United States. The United States in that clause necessarily must reference the several states, as the government has no means of securing credit on its own. The people compose the several states. That clause authorizes the Congress to borrow money on the credit of the people. Hmm. Both parties receive value in the transaction, and both parties receive rights. Both parties give value, and both parties give rights. Value usually means some kind of consideration. Article 3 of the Commercial Code further clarifies value when negotiable instruments are involved, but the more general definition is in Article 1 201. The next section contains many examples of exchanges of value for rights, and conversely, exchanges of rights for value. Value is a complicated concept. So several examples are given to help to clarify. Value is subtle. So notice the subtleties of the examples. The specific value for each example is bolded. The following interpretations for subsection A through D deals with persons and credit under public policy through the law merchant. Value, except as otherwise provided with respect to negotiable instruments and bank collection, a person gives value for rights if he acquires them. A, in return for a binding commitment to extend credit or for the extension of immediately available credit, whether or not drawn upon and whether or not a chargeback is provided for in the event of difficulties in collection. A person gives value to another party in exchange for interest in the other party's property. He acquires rights, interests, in return for giving a binding commitment to extend credit or giving a binding commitment for the availability of credit to the party giving the person the rights. Those rights might be in the title of real property or for capacity to sue to get the title to real property through the court order. Those rights might be in benefits provided by the United States. They might be in a distribution from the trust created by the Constitution. It does not matter if the party gives giving the right draws on that commitment to extend credit. It does not matter if a chargeback is provided if the party receiving the credit and giving the rights has difficulty in collecting the credit. The whole money system of the United States is based on extension of credit. Almost everything transaction in the public is based on credit. There is constantly an exchange of value for rights and rights for value happening in the United States. This results in transfers of digits from one account to another. Public to public. A person, which is a borrower, gives value, which is a right to foreclose, asset on the bank's books for rights from the creditor. Use of public credit. If he, which is the borrower, get those rights, use of public credit in return for his borrower commitment to extend credit. Let me read that again. And I'm going to read it without this, right? Without these things here in brackets. A person gives value for rights if he gets those rights in return for his commitment to extend credit. Yeah? So if you give a commitment to extend credit, right, you're supposed to get something back. Value for rights. A person, which is the lender, equals creditor, gives value, use of public credit, to debtor for rights from debtor to foreclose if he, the lender, equals creditor, gets those rights to foreclose in return for his commitment to extend public credit to the borrower. Again, let me read that again. A person gives value for rights if he gets those rights in return for his commitment to extend credit. There we go. Person gives value for rights in return for borrower. Wait a minute. Let's. Person gives value for rights in return for borrower. Give right to this right to foreclose, use of public credit, promissory note. Lender. So this basically is breaking it down, right? So it says, what are the values given right here by the borrower? Right to foreclose. What's the value given by the lender? The use of public credit. And then here we go. It gives right to foreclose, use of public credit, and it's a promissory note. Right to foreclose, extension of public credit. So let's read on. Private to public. A person, which is the borrower, gives value, private man's credit via signature on a note for rights from the creditor, use of currency if he, the borrower, gets those rights, which is the use of currency, in return for his, the borrower's, commitment to extend private credit to the lender from the man who represents the borrower. A person, which is the lender, equals the debtor, gives value, liability on its books, for rights, the use of private credit, if he, which is the lender, gets those rights, use of private credit, in return for his, which is the lender, commitment to extend public credit to the debtor. So it seems that the creditor is extending the credits. And let's see here. Public to public. A person gives value for rights in return for what the borrower gives a man's signature, use of currency, with the extension of private credit. And the lender creates a liability on the books, use of private credit, and the extension of public credit. There are two different actions happening in this scenario. One is public to public, the other is private to public. Nothing can happen on the public side until someone on the private side signs something. The signature can be advantageous to the man or not. It's up to him. The man is an accommodating party who receives nothing for lending his name or credit to the public event unless he negotiates terms that are favorable to him. If the United States presents the terms and they are accepted without renegotiation, the man is just an accommodating party and can expect to receive no rights in return for the value he gives by lending his name and credit to the United States. A bank cannot lend its own credit. When a bank extends credit, it has to use someone else's credit and extend it to a third party. It is not a loan, B2, B2C. It is a lengthening the process, A to B to C. The credit comes from A, which is the man, the lender, in the private, through C, which is a US citizen, agent for A, to B, which is the banker, supposedly the lender, in the public, to C, the United States citizen borrower in the public. The borrower is both a debtor and a creditor on the same transaction and cannot go into the public. So the US citizen has to represent the man in public. The US citizen needs hands to sign instruments. So the man has to represent the US citizen and supply the energy. The man will be presumed to be an accommodating party unless he negotiates a contract that has terms more favorable to him. If the man permits his signature to be used with no terms for payment to him, he just waived his rights. The US citizen is both the transferor and the transferee on the instrument in the public. Instruments that are issued and transferred for value are requests for man's private credit. They're credit applications. He can endorse them properly and be a creditor, or stand silent and be a debtor. It's up to him. It's all up to him. The public to public value on the previous interpretation is the right to foreclose an asset on the bank's books and the use of public credit in return for a promissory note and the extension of public credit. The private to public value on the previous interpretation is the man's signature on the note and the liability on the bank's books in return for an extension of private credit to facilitate the extension of public credit. There can be no public credit without getting credit from the private side first. The people in the several states are the only ones who have credit because they are the only ones with energy that does not belong to somebody else. Fictions have no energy of their own. Since money of exchange is not used in the modern commercial system, credit is the medium of exchange through money of account. Money of account is digits on an accounting ledger. All loans in the public necessarily must be made on the private credit of the people. The people have to supply private credit that public lenders extend to borrowers in the public. No wonder the lender always says they are extending credit. They are extending the people's credit from the private side into the public and returning it to a fiction represented by one of the people. Value is given on both sides. Value is accepted on both sides. This 1-201 definition is in Article 1 of the Commercial Code, so it does not apply to Article 3 negotiable instruments, but it is necessary to understand the duplicity of value to understand acceptance for value. The following interpretations of 1-201 A deal with a public person created by the United States as a debtor and the United States as a creditor, as well as the United States as the debtor in a private man as the ultimate creditor through the public person he represents. These are still dealing with persons and credit under public policy. Okay, give me 1 second. Let me. Oh man, we have people right here wanting to join in, and I didn't see it. Give me 1 second. Let me put them in. My bad. My bad. I'll be checking this more often. I start reading and I just forget.
The
My bad.
It's
My
okay.
bad.
It's all
My
good.
bad, guys. Okay. I think I'm gonna have to figure out how to have somebody else help me
Check
put
that part,
people
right?
in. Hmm. All right. Sorry about that, guys. Let's continue. This was a good part, though. I really like this part here. This one really shed a lot of light. Okay, here we go. Public to public. A person, which is the United States, gives value, which is a certificated security, which is the birth certificate, which is the US citizenship, for rights to use the US citizen as surety. If he, the United States, gets those rights to use the US citizen as surety in return for his United States commitment to extend public credit and benefits to the US citizen. Hmm. A person, which is the US citizen, gives value, which is a pledge to the United States, for rights to operate in commerce in the United States if he, which is the United States citizen, gets those rights to operate in commerce in the United States in return for his US citizen commitment to extend public credit to be a surety to the United States. So, it seems that the United States gives value by offering a birth certificate for the use of private credit, public credit, and benefits in return for public credit and benefits. The U.S. citizen, he pledges to the United States. That's a pledge. It's I promise to pay for he gives rights for commerce in the U.S. and being a surety for the U.S. Okay, let's see. A person, which is the United States, gives value. Certificated security equals birth certificate and U.S. citizenship for rights. Get private credit if he, the United States, gets those rights to use private credit in return for his United States commitment to extend public credit, which is the distribution from trust to the man through the U.S. citizen. A person, which is a U.S. citizen, gives value, which is man's private credit, to the United States for rights, which is to operate in commerce in the United States. He has a right to operate in the United States now. As long as he gives credit, which is man's credit, to the United States, now he has the right to operate in commerce in the United States. If he, the U.S. citizen, gets those rights to operate in commerce in the United States in return for his commitment to extend credit of the man who represents the United States. Okay, so private to public. The United States gives value, which is the birth certificate, for this rights, which is to get private credit. So the United States gets the right to get private credit in return for the extension of public credit. So the US citizen gives value by giving man's private credit for rights to operate in commerce in the United States in return for the extension of private credit. It's making more and more sense. On the public side, the birth certificate represents value as security for a pre-existing claim the United States has against the United States citizen. On the private side, it is, hold on 1 second, I think. this. Okay. Where were we? Let me read it again. On the public side, the birth certificate represents value as security for a pre-existing claim the United States has against the U.S. citizen. On the private side, it is security for a pre-existing claim the man has against the political state for using his description without paying for it. It is an antecedent claim the man can present as a counterclaim when the United States brings a claim against the person the man represents. The birth certificate secures the obligation. The state, as an agent for the United States, has to demand, since no payment has ever been made to the man and technically cannot be made. Let me read that again. The birth certificate secures the obligation the state, as an agent for the United States, has to the man. So the birth certificate secures the obligation the state has to the man. So the birth certificate represents an obligation due to man. Since no payment has ever been made to man and technically cannot be made. Yeah, because if we give them credits, we're giving them our divine commercial energy. What can they give us being a corporation? Nothing. So we have to come up with a scheme for that, right? So the inches and pounds description of the baby on the application for the birth certificate constituted a symbolic delivery of the baby into the United States. What happens in the United States stays in the United States. The baby and the man cannot go into the United States, but the person named on the birth certificate can. The United States cannot go into the private states, but the man representing the person named on the birth certificate can. The baby grew into a man, and the rights the baby had to payment for use of his description carry on to the man. If the man does not do something with that certificated security, birth certificate, it is considered abandoned. Abandonment is waste. So the United States will use the birth certificate to prevent waste until the man decides to use it. How very kind of the United States. Subsection B can also be read from several different perspectives. Both parties in each scenario give values and rights and receive values and rights through the agreement. The following interpretations deals with individuals and corporations. General definition: value, except as otherwise provided with respect to negotiable instruments and bank collections. A person gives value for rights if he acquires them as security for or in total or partial satisfaction of a pre-existing claim. Okay, so let's see what all that means. Usually, a person gives value when he is exchanging them for rights. He is acquiring a security for that one transaction. Those rights might be in the title to real property, or capacity to sue, or for performance. According to subsection B, a person, which is the United States, can give value, which is benefits, for rights, pledge, the United States, is acquiring from the U.S. citizen as security for satisfaction of a claim that already exists, which is the national debt. The rights the United States gets from the U.S. citizen secures payment or performance on that pre-existing claim the international bankers have against the United States and its sureties. The person giving the value, which is the United States, has supposedly already received a promise of some sort from the US citizen. Now, the person, United States, is giving value again to get more rights that he will acquire as more security for total or partial satisfaction of that pre-existing claim, which is the national debt. A tax bill is considered value, as is a libel of information for a quasi-criminal case against the United States citizen for violation of the United States statutes. Now, okay, hold on. Let's see. I just want to Google this really quick. Libel. Let's see what that means, right? Give me 1 minute. Let me pull this up. Share this tab instead. It says here, in law, libel means a published false statement that is damaging to a person's reputation, a written defamation. Okay, a written defamation. Let's go back and see what it says. A tax bill is considered value, as is a libel of information for a quasi-criminal case against a United States for violation of the United States statutes. The United States is giving value by issuing an instrument for value. That instrument carries a security interest in the instrument that is being issued. That can be considered to be value. In exchange for giving the U.S. citizen a security interest in the instrument, the United States is looking for rights in the property owned by the U.S. citizen. It is also looking for a right to seize the body. All of this is done to collect revenue from the U.S. citizen as surety. If the man who represents the U.S. citizen does not recognize the value that is being given, that waiver does not negate the right the United States is acquiring in the transaction. So basically, we shouldn't be sleeping on our rights. We should be recognizing these things here and doing something about it, which is mainly a counterclaim. And let me just check and see if everybody's good. Sabea is still disconnected. All right, let's go back. In a normal situation, the party in a normal situation, the party giving the rights. Hold on. I think somebody muted. Can somebody check your mics and put it on mute just for a little while? Okay. There we go. In a normal situation, the party giving the rights receives the value through the transaction. A right is a remedy if the party who gave the rights is later accused of not performing. The right he gave as security when he received the value can be used to seize the property to satisfy the terms of the agreement. In subsection B, a pre-existing claim makes an appearance. The United States already promised to repay the international lenders, but if it doesn't pay, the international lenders can use United States statutes to collect from U.S. citizens. Both parties give value and both receive rights in each transaction. The value given can be absolutely anything that is sufficient to support a simple contract in the jurisdiction where the agreement is made. The rights given can be anything to secure the obligation incorporated in the agreement, including defenses against claims made by the parties against each other. Public to public. A person, which is a creditor, which is a corporation, gives value, the use of credit, example mortgage, for rights to foreclose and defenses if he, the creditor, acquires the rights to foreclose and defenses as security for satisfaction, which is payment, for a pre-existing claim, which is the national debt. The debtor's promise to return credit is a second promise. The first promise is a pledge to not question the national debt. A person, which is the debtor, the U.S. citizen, gives value through a promise for rights, which is to use credit and defenses. If he, the U.S. citizen, acquires the right, which is the use of credits and defenses, as security for satisfaction, extension of credit, of a pre-existing claim, which is the beneficial interest in the trust created by the Constitution, the approval of credit application is the second promise. The first promise is the constitutional oath the president took. Here it says public to public person. The corporation gives value by the use of credit for rights to foreclose and defenses as security for the national debt. So the corporation gives the use of credit in exchange so that it has the right to foreclose and it has the right to use defenses as security for the national debt. The U.S. citizen, he gives value by giving a promise in exchange for rights, which is the use of credits and defenses. And it's secured for as security for beneficial interest. Private to public. A person, just a creditor, the U.S. citizen, gives value, man's signature on an application, for rights to use the public credit if he, the U.S. citizen, acquires the rights to use public credit as security for satisfaction, which is the distribution from the trust, for a pre-existing claim, which is man's beneficial interest in the trust. B, a person, which is the debtor, the corporation, gives value, use of credit, public credit, for rights, which are defenses, if he, the corporation, acquires the rights, defenses as security for satisfaction, trust distribution of a pre-existing claim, which is man's beneficial interest. What's going on here? In this trust. Here you go. Computer's glitching. So basically the person, which is the U.S. citizen, this is a private to public, right? Private to public. The U.S. person, which is the citizen, gives value by giving man's signature for rights in exchange for the use of public credit as security for distribution from the trust. The corporation gives value by the use of public credit for defenses, for rights of defenses, as a security, which is the beneficial interest in the trust. The following interpretations deal with creditors of the United States and the United States, backed by U.S. citizens as sureties for the United States for the national debt. A person, which is a debtor, corporate, United States, gives value, new reorganization plan to pay, for rights, defenses against foreclosure, as a security, which is a promise not to foreclose now, for satisfaction, partial performance of a pre-existing claim, which is international bankers' right to foreclose on the United States. A person, which is a creditor, international bankers, gives value, approval of new reorganization plan for extension of time to pay, for rights, which is to foreclose later as security, promise not to foreclose now, for satisfaction, which is a new payment plan of a pre-existing claim, which is terms of loan agreement national debt. Person, United States gives value, reorganization plan for rights, which are defenses, as security for partial performance. The creditors of the United States approval of plan gives value by approval of plan for the rights to foreclose later as a security for promise not to foreclose. So the promise right here is a security, and the performance right here is a security, the partial performance. Satisfaction in this subsection can refer to the statutes the United States created for its creditors to use the more expeditiously collect through forfeiture actions. It can also refer to United States courts created for its creditors to summarily condemn property of the reorganized United States gave to its creditors, promising performance on a pre-existing claim, which is the national debt. The following interpretations deal with the United States as the agent and the people as the principals, and with the United States as trustees and the people as beneficiaries. Let's see if there's anybody who needs to join in. Give me 1 minute. Wow, I'm gonna have to read these chats later on, man. Okay, there's somebody that needs to join in. There you go. Cool. Perfect. All right. So, right now, as we're reading this, obviously, it's a little bit confusing at first, but he gets more into details, breaks it down more and more and more. And obviously, when we're done here, we can go and read this again on our own. He really does break this down very, very good. But it takes us having to read it more than once. Okay. B, a person, which is the corporate United States. He gives value, which is a certificated security, the birth certificate, for rights to create money on the signature of man, which equals borrowed from the people, as security, which is promised not to deny or disparage rights of the people, for satisfaction, which is the acknowledgement of obligation of the people, of a pre-existing claim, which is a beneficial interest in the trust created by the Constitution. So the United States gives value by giving a birth certificate for rights to borrow from the people as security for the 9th article of Bills of Rights. So the reason they give birth certificate, right, is for the right to borrow from the people. A person, which is an officer in the federal government, gives value, which is Article 6 oath, for rights to hold an office as security, which is a promise to support this Constitution, for satisfaction, which is performance, of a pre-existing claim, which is the people's beneficial interest to the trust created by the Constitution. So a person, which is an officer, he gives value. He gives his oath, which is a promise. In exchange, he gets to hold office as a security for the beneficial interest. A person, which is the president, he gives value, which is an Article 2 oath, for rights to be commander-in-chief as security, which is a promise to preserve, protect, and defend the Constitution, for satisfaction, which is performance of a pre-existing claim, which is a people's beneficial interest in the trust created by the Constitution. So the president, he gives value by giving a promise, here's his oath, in exchange to hold the office for as security for beneficial interest. A person, a state, i.e., Ohio, etc., gives value, which is the office in the federal government, for rights to be part of the Union of American States, equals federal United States, as security, which is a promise to abide by the terms of the Constitution, for satisfaction, which is performance on terms of the Constitution, of a pre existing claim, which is a promise to pay creditors of the Confederacy. So, a person, which is a state, gives value to hold federal office for rights to be part of the Union as security for payment of national debt. A person, which is a state, i.e., Ohio, etc., gives value, which is a constitution, for rights to be recognized internationally as security, which is promised to pay creditors of the Confederacy, for satisfaction, which is acknowledgement of international law of a pre-existing claim, need for plan to pay international. Oh, okay, here we go. Got a little bit of. Okay, 1 minute. Computer's running slow. Okay. So a person, which is the state, gives value, which is the Constitution, for rights, which is the recognition as a state, as security for payments of debts. So a person, state citizen, by mom, gives value, which is a signature on application for birth certificate, for rights to be beneficiary on the trust, as security, which is promise for satisfaction, distributing from the trust of a pre-existing claim, beneficial interest in the trust created by the Constitution. So, person, which is a state citizen, gives value, gives its signature for rights, beneficial interest as security for distributions from the trust. So, I mean, this is why it's important for us to create our own trust. That way we can control it. Obviously, if it's the public trust, we can't control that. But if it's a private trust and we're trustees of it, then we have some control over that. But we have to recognize that this is basically a framework right here. A person gives value for rights as security for. Subsection D deals with buyers and sellers. Notice that both subsection B and C refer to a pre-existing arrangement. B brings in a pre-existing claim that necessarily results from a pre-existing contract, addresses the delivery on a pre-existing contract. On the public side, creditors of the national debt have a seemingly priority position in the commercial code. The only right higher than that of the international creditors is that enjoyed by the people in the several states. The people have first and foremost position in equity in the United States as beneficiaries of the trust created by the Constitution and as beneficiaries of the trust created by President Roosevelt in 1933. The people, through the persons they represent in the United States, have priority stock in corporate United States. So the people have stock. I mean, that's basically the birth certificate. USC 1-201, general definitions, value. Except as otherwise provided with respect to negotiable instruments and bank collections, a person gives value for rights if he acquires them by accepting delivery pursuant to a pre-existing contract for purchase. Excuse me. Okay, let's see. We are at 7:44. We're at page 20. I don't think we're going to be able to finish this today. I'm probably going to read maybe 5 more pages, and then we're gonna continue this a second part next week, if that's okay with you guys. But this is a good document to read, though, man. I mean, it shares a lot, but it's just so much, you know. Okay, C, a buyer, which is a debtor, gives value, which is promise or actual payment, for rights, which is receipt or defenses. If he, the debtor, acquires the rights, which are receipts, as defenses by accepting delivery of product on a pre-existing contract for purchase. You see how it says rights are receipts and receipts equal defenses? So when we go to, I say we go to a supermarket, right? And we hand them over, I don't know, $20 bill, or we swipe our debit card. We swipe our credit card. Regardless, what we're doing is we're giving them some type of negotiable instrument. And we, in exchange, we get something called a receipt. Now, the receipt are defenses. Now, if you look at that receipt, it does have a title of the debt of the company or the corporation, which is either a supermarket or gas station. It does have a title on it, and does list out certain inventories or certain stocks or certain shares of the company. So by giving them something of value, which is, let's say, a negotiable instrument, in exchange we get back receipts, which are defenses. So by accepting, going back to this, by accepting delivery of promise or actual delivery on a pre-existing contract for purchase. So it says here, a person gives value for rights by accepting delivery. So a person, which is the buyer, gives value by delivery of promise or payment. Now remember, when we swipe our cards, right? If you swipe your debit card or you swipe your credit card, your debit card is basically, I would believe, in my opinion, that's like an order to pay, and a credit card would be a promise to pay. Whatever we give, we're giving them a negotiable instrument. So a buyer gives value by delivery of a promise or a payment in exchange for the rights, which is a receipt, by accepting delivery of the product. Now the seller, which is the supermarket or the gas station, he gives value by delivery of product for rights, which is a receipt, by accepting delivery of payment or payment. So in this case, the person gives value, which is the product, for rights, which is receipt. What would be the receipt? Well, that would be the negotiable instrument tendered, by accepting delivery, which is of the promise of repayment. The terms buyer and seller have a broad scope of application in the commercial code. C, a buyer, United States citizen, gives value, which is a pledge, for rights to be a citizen, if he, the United States citizen, acquires the rights, which is citizenship, by accepting delivery of benefits on a pre-existing contract for purchase, which is the application for birth certificate. You see how I say the contract for purchase signifies the application of a birth certificate? Now remember, purchase, the definition is the acquisition of a security, right, or an asset. So let's continue to read. C, a seller, right here, a seller, the United States, gives value, which is the citizen, for rights to use the U.S. citizen as a surety. If the United States acquires the rights to be U.S. citizen as to use the U.S. citizen as a surety by accepting delivery of a pledge on a pre-existing contract of purchase, which is the application for birth certificate. So here again, the seller is the United States, gives value for sin. Let's see that. This person, United States citizen, he gives value, he promises, he gives a pledge in exchange to be a citizen, to have citizenship, that's his rights, by accepting delivery of the benefits. As soon as he accepts the benefits, that's it right there, right? He's completed the transaction. He gave a pledge. He got the rights to be citizen. Now he has received the benefits of by acceptance of the benefits. So the U.S. person, the United States, he gives value by offering citizenship in exchange for the rights of citizen to be surety by accepting delivery of a pledge. So when this is delivered, when the pledge is delivered, then the value for rights occur. In a forfeiture case, the defendant can be deemed to be the buyer, and the prosecutor can be deemed to be the seller. Interesting. C, a buyer, which is a defendant. He gives value through a plea and a signature for rights, which are civil liberty or liberties. If he, the defendant, acquires the rights, which is a civil liberty, by accepting delivery of charges on the indictment on a pre-existing contract for purchase, which is the application for citizenship and residency. The seller, which is the United States, he gives value, which is civil liberty, for rights to condemn the defendant's property if he, the United States, acquires the rights to condemn the defendant's property by accepting delivery of plea and signature on a pre-existing contract for purchase, which is the application of citizenship and residency. So the person, which is the defendant, he gives value by pleading or giving a signature for rights, which is civil liberty, by acceptance of delivery of an indictment. So what's an indictment? Let's see what's an indictment really quick, right? Or we have a better idea. Indictment. Indictment is simply a formal written accusation of a crime. It charges a person with an offense and is issued by a grand jury against an individual who is charged with a crime. Well, it's good to know. Let's go back. Wait a minute, where are we? Okay, let's see. Well, I'm having a little bit of trouble here with my computer. Okay, got it. I see two people got disconnected and they're not able to connect back. Says device is not connected. Okay. Let's get back to it. So again, the person, which is the defendant, he gives value by a plea or signature for civil liberty of an indictment. The person, which is the United States, gives value, which is civil liberty, for rights to condemn property by accepting the delivery of a plea and signature. In all penal actions for violations of statutes, the national debt is the pre-existing contract for purchase that influences the conscience of the judge in making his decision. In those cases, the defendant is a U.S. citizen who cannot question the national debt. He is deemed to be the surety for the buyer, which is the United States, and the prosecutor represents the seller, which is the international lenders. A U.S. citizen who refuses to be a surety can be viewed as giving aid and comfort to enemies of the United States. Let me read that again. A U.S. citizen who refuses to be a surety can be viewed as giving aid and comfort to enemies of the United States. So as soon as you refuse to be surety, or the US citizen refuses to be surety, he is deemed an enemy of the state. That is the definition of treason. Once the U.S. citizen is found to be in treason, he can be viewed as a resident. Penal actions are against residents. It is the property of residents that can be seized and condemned and forfeited, which is confiscated. The Book 39 IRS arguments that don't work and why explains, wait, let me read this again. The Book 39 IRS arguments that don't work and why explains this process in much more detail. It can be found in www.lulu.com. A buyer, which is the U.S. citizen, equals surety, which is the defendant. He gives value by a plea or a signature for rights, which is the reimbursement. If he, U.S. citizen, acquires the rights, which is reimbursements, by accepting delivery of the charges of the indictment, equals bill for payment, right? So the charges on the indictment are the bill for payment. So that means these charges can be converted into a bill of exchange because it's a bill on a pre-existing contract, which is the national debt for purchase, which is a loan of credit to the United States. A seller, which is the international bankers, which is who the prosecutor is representing, gives value to the extension of credit to the United States for rights to seize property of the United States. If he, the international lenders, acquires the rights to seize property of the United States by accepting delivery of plea and signature of surety on the pre-existing contract, which is the national debt for purchase, which is the loan of credit to the United States. So, person, U.S. citizen, surety, gives value through a plea and signature for rights for reimbursement by accepting delivery of the quote-unquote indictment. Persons, the international lenders, they give value through extension of credit for the right to seize property by accepting delivery of the plea and signature of the surety. So as soon as they accept this, it's already a contract too. Their contract, as we accept this, we're already in, or the U.S. citizen is in a contract. Subsection D deals with anything that is not addressed in A or B or C. UCC 1-1-201 general definitions. Value, except as otherwise provided with respect to negotiable instruments and bank collections, a person gives value for rights if he acquires them, generally in return for any consideration sufficient to support a simple contract. A debtor, which is a buyer, in this case a buyer, or a creditor, which is a seller, gives value, any type of consideration, for rights, which are interest in property and defenses. If he acquires rights, if he acquires interest in property, and if he acquires defenses, in return for anything of value that constitutes consideration sufficient to support a simple contract requiring performance by one or both parties. So you have a person, which is any person. He gives value or she gives value, meaning any consideration, for the rights to interest in any property in return for any consideration. The definition of value in 1-201 does not actually define value. It merely gives us examples of what circumstances might incorporate value. To recap, From the above interpretations, value appears to be or to imply some kind of promise to provide something or to do something. Extension of credit, private man's credit via signature on a note, assets on a book, liability on books, pledge to the United States, use of credit, payment, new reorganization of plan to pay, approval of a new reorganization to play for a new approval of a new reorganization plan for extension of a time to pay, Article 6 oath, Article 2 court oath, office in the federal government, constitution, promise or actual payment, promise or actual delivery, pledge, citizenship, security, interest in property, civil liberty, plea and signature, extension of credit, any consideration sufficient to support a simple contract. They are all beneficial to someone or something and are therefore valuable. This list is by no means exhaustive. That means this list could go on and on and on and on. Constitutional oaths, the foundational agreement behind every commercial and political event in the United States, is the Constitution. It is primarily an offer made by the states to those who want to be part of the federal or national governments, and secondarily, an offer made by the states to those who want to do business with the federal or national governments. This was a very dangerous document. It created a potentially huge commercial machine that had the power to do untold harm to the people. It had to provide a means to pay creditors so the states could be recognized internationally for commercial purposes. At the same time, it had to secure the people's rights so the commercial machines would not eat the life out of the people. The only offers made back to the people to secure their rights are the two oaths required by the Constitution. These two oaths are the condition put in the agreement ratified by the states to assure the people who get the benefit from the Constitution by holding offices keep their commercial machine away from the people in the several states. One is the oath required in Article 6 of members of the legislators and all executive and judicial officers of the United States and of the several states. It says here, Article 6, Section 1, Clause 3. The senators and representatives before mentioned and the members of the several states legislators and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. But no religious test shall ever be required as a qualification to any office or public trust under the United States. The other is the oath required in Article 2 of the President. Article 2, Section 1, Clause 8. Before he enter on the execution of his office, he shall take the following oath of affirmation. I do solemnly swear or affirm that I will faithfully execute the office of the President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. It's interesting because it doesn't say the United States of America, it just says the United States, all corporate. It's still a contract, though. Still an obligation. There are no Article 6 oaths that can be found for any members of the legislature, state or federal, or executive or judicial officers of the United States or of the several states. They all have United States Code Title 5 oaths. The president cannot take a Title 5 oath of office. He already has another oath to the people. He and others are deemed to be qualified to hold and enjoy any office of honor, trust, or profit under the United States. Notice that the only definitions who are elected or appointed to an office of honor or profit in the civil service or uniform services are required to have a Title V oath. They do not hold offices of trust. Hmm, The president does. Only members of the legislators of the states of the United States and the United States and executive and judicial officers who are bound by Article 6 oath can hold offices of trust. Those who take the Title V oath of office can hold offices of honor or profit under the United States. An oath is different than an oath of office. 5 USC 3331 Oath of Office. An individual, except the president, elected or appointed to an office of honor or profit in the civil service or uninformed services shall take the following oath. I, AB, do solemnly swear or affirm that I will support and defend the Constitution of the United States against all enemies, foreign and domestic, that I will bear true faith and allegiance to the same, that I will take this obligation freely without any mental reservation or purpose of evasion, and that I will well and faithfully discharge the duties of the office on which I am about to enter. So help me God. Judges have the Title V oath of office. Title 28, Section 543 says, each justice or judge of the United States shall take the following oath or affirmation before performing the duties of his office. I, name, do solemnly swear or affirm that I will administer justice without respect to persons and to do equal right to the poor and to the rich, and that I will faithfully and impartially discharge and perform all the duties incumbent upon me as officer under the Constitution and laws of the United States. So help me God. Now, the only constitutional oath able to be found in this oath the president take no, the only constitutional oath able to be found is the oath the president takes, which is word for word as the required text in the Constitution. He does not take an office. He does not take an oath of office in Title V. As long as there is one officer with an oath required by the Constitution, not an oath of office required by Congress, the people still have a trustee for the trust on which the people are the beneficiaries. That beneficial interest is what gives people the right to accept for value instruments that are issued for value. They have an antecedent claim from the pre existing contract. Their claim is a right to enjoy freedom and liberty. It is based on constitutional guarantees. Since 1933, the people also have a right to a distribution from another trust created by President Franklin D. Roosevelt. Since 1933, all property is held by the state. That means the state has the legal title to all substances in the states, but the people have equitable title through their beneficial interest in that trust. Taking gold, no, sorry, Taking control of the gold in 1933 would have been unconstitutional if the new trust had not been created. The president's oath is an offer to the people in the several states. It might be prudent for the people to accept his oath. It is not an oath that is issued for value, it is an oath made in good faith by the man. The principles of offer and acceptance apply to this very critical premise. If the people have not accepted that oath, how can they expect the man who made it to to be working for their benefit? As far as he is concerned, it may appear that none of the people wants him to be their trustees. All presumptions, right? You got to accept that offer. Since 1933, the only money in circulation in the United States is credit borrowed from the people. The commercial code adopted by every political state of the United States provides for value to be whatever consideration is needed to support a mere simple contract. The president's oath is consideration sufficient to support the simple contract the president, executive trustee, has with the people, beneficiaries. He does not have an oath of office. That is different than an oath. All legislative, executive, and judicial officers performing under him in his capacity as commander in chief have oaths of office. He has a constitutional oath. Value is anything recognized as a pledge or the result of a pledge. Value, let me read it again. Value is anything recognized as a pledge or the result of a pledge. The birth certificate is the result of the president's oath. Without that one oath, the birth certificate would just be evidence of the obligation every U.S. citizen owes to the United States. Without that one oath, the birth certificate would not be evidence of the obligation to the United States owes the obligation the United States owes to the people. On the public side, the birth certificate represents value and is evidence of a pledge by the U.S. citizen to be a surety for the United States. On the public side, it is a security for the pledge of an allegiance to the United States and its statutes made by the U.S. citizens. So these are about, see, okay, let me read this in because this is all public. This is on the public side. The birth certificate represents value and is evidence of a pledge by the U.S. citizen to be a surety of the United States. On the public side, again, it is a security for the pledge of allegiance to the United States and its statutes made by the U.S. citizens. Now, on the private side, it is a receipt and is evidence of a promise made by the president to the people. On the private side, it is security for the promise of distributions from the trust to the people as beneficiaries. It is a receipt for the use of the baby's physical description that was symbolically delivered by an informant, which is mom, to the United States. The set-off resulting from accepting an instrument for value is distribution from the trust. Set-off equals distribution. Set-off equals distribution. So we are on page 24. I'm just going to read this one little part right here of acceptance, and we're going to, in fact, I think we're going to end this now. Yeah, we're going to end it now. I got to do something in a little while, but we will continue this, and we're going to start off here in acceptance. We come back. Let's see. Oh man, set got cut off and I didn't notice. So guys, what we're gonna do, let's just have a little discussion really quick. I see some people had to leave. So I know it's late in some places. But isn't it interesting? This so far, we've read half of it, and it's a lot of juicy stuff. Obviously, a lot of things to go around or go over again. It just breaks it down how the reason why they, drag us to court, send us to prison, issue warrants, all of those things right there, which seem so wrong, which is definitely probably wrong because we don't know the name of the game. We don't know how to play the game. They didn't tell us this, but it appears that legally, they have a right to do it. Legally, you know how legal works, right? But there are remedies. They get rights. we get rights. They give value, we give value. So we have to recognize what we have that they need and what they offer to us, which we also need or can use as a benefit. All right. Let's see. Stop sharing. How do I do that? There we go. Anybody want to add anything? Anybody got anything to say? You're welcome, Ali. I see all the chats. I will go over it later.
You get unlimited data. You get America's most reliable 5G network.
How you doing, Seth? You wanted to add something, Seth?
So you can
No,
Yeah.
my mic just came on, my friend.
Oh, okay, that's cool. That's cool. I thought you wanted to add something.
So I'm guessing that once we give it value, we actually transfer the note to the actual bank, and then from there the bank, what it does, securitize it.
Well, what was interesting, what this explained is that anytime we're engaging in the public, we are actually engaging as two entities. So obviously, we're engaging as a public entity and a private entity on behalf of the public entity. So obviously, the U.S. citizen or the Belize citizen, he's a debtor, and he can be basically uh, forgiven by the use of the beneficial interest which he holds through the having the signature of the man. So I think this will go further into a little bit more how to use the trusts, but basically is how we express the contract when we get the bill, right? When we get the instrument and we return the instrument, depending on how it is returned and how it is expressed, the contract is expressed, then that goes through a counterclaim if we so wish. It can be a counterclaim. So meaning, what is a counterclaim? We're claiming, in a way, to have rights to that instrument. So let's say this is my interpretation of it, okay, so far. Let's say we do get a bill, right? It could be any bill, even a court charge. We get that. Now, we now have the right to perform some type of action. We can act as a debtor and just send them a piece of other paper, another negotiable instrument, which again is a contract, and they keep it, they accept the contract, right? Or we can do a counterclaim by saying, hey, I'm going to send you this bill of exchange with instructions as to use it, right, as an asset for it to be applied to the principal account in order to discharge obligations of the principal debtor. So then what we're doing is we're now basically claiming that we're coming in with the right to use that instrument as a creditor. But then at the same time, remember, they need to get something out of it, right? So a lot of times if we are able to give them the interest, well, who's the interest? Who gets the interest? And later on, we'll go into it, which will basically demonstrate that is actually the tax.
The tax, yeah.
So the tax department collects for all interest holders, all creditors. So they will collect for the creditors in exchange for something, right? They need to get something, which is the tax. And again, we'll probably go more into details in that. But yeah, when we receive these instruments and we give it back to them, if we do to give it back, like a lot of times we receive bills and all we do is we stay with the bills and we just give them back a negotiable instrument, right? Or we give them a check or something. Also, we stay with these instruments. We don't really do anything with them. So it is basically instruments that go abandoned. And a lot of time these companies are set up in a way that they will use those instruments and convert them into something called a secondary marketable security. And an example of that would be a debenture. Right? So if you Google debenture, you'll see that those things are secondary marketable securities. And all these companies, especially like utility companies, if you go to, like here in Belize, I found that the utility companies are, man, these guys make a killing off of debentures, just a killing. So many people don't claim their debts through their private exemption. So it is then reinvested through secondary marketable securities. And I found that the utility company sends that to a trust company, which is a bank. And then the trust company manages and administrates all of that, all those debentures. And it has a maturity date and all that. So it's very interesting how they have all that set up. And it's even more interesting that these people that work within the utility companies, and they're not even aware of this. I am 100% sure, not all of it. I think because the ways things are set up, that there's departments, all these different departments that are separated from each other, and you know how everybody has to sign a confidentiality form, especially when dealing with accounts. They can't really intermingle in a way that they would figure it out. So it's a beautiful setup. It's like a triangle, like the ones on the bottom, they don't know nothing, but as the higher you get to the top, the more you know. But yeah, so I get into that. But yeah, man, I guess we're gonna call it the night. I appreciate you guys for joining in. I'm gonna upload this into YouTube, and it'll be available for it to be seen by anybody. And next week we're gonna continue on the second part. So I just want to say thank you to all you guys, and I appreciate you. And we're gonna continue learning. Uh-huh.
Yes, sir.
All right then. Well, I'll wish you guys a good night. We'll talk later. Peace and love to you all.
Peace, love, and prosperity. Many blessings, my friend. Thank you.
Many blessings. Thank you too. Take care.
Yeah, thanks for everything, and I'll say good night.
Thank you too, Lana. Appreciate you.
Most people saw 90% clearer skin at 4 months, and the majority saw clear 5 years. Your body is proven to significantly reduce joint pain, stiffness,